Very warm good evening to all. Today's topic is about the legitimacy of the children or the offspring. जिसको हिंदी में बोलते हैं संतति. Now this is very important chapter in the Indian Evidence Act, which is used very widely in the matrimonial disputes. And the reason behind this is that whenever there is a doubt about the legitimacy of the children in our country, this section is used by the litigants to find out a way out of the same. Now, when they feel that the offspring or any children is not born from them, they have any doubt, they use this section. But if you read this section 112 of the Indian Evidence, it is the most powerful section which protects the innocent children. Now, the legislature intention and spirit behind enacting this section was to save these children from branding them as bastard children. Now, this word is very difficult even to pronounce here, but when I say that law do not want to bastardize any child, whether it may be a girl child or the male child. Now, when they say that you cannot bastardize this child, and also beyond that, there is one more thing and spirit behind that, and you cannot just get up from your seat and say this woman is not just, she's unjust. Now, this is the reason that this section has been enacted. Now, this section came from the, it is more than 100 years old now. This sometime the law says that there is a improvement in the lot of things. There is a medical improvements. Now the science has gone ahead, and we should be reforming or reforming this section, or maybe there should be some amendment this section. But the legislature intention behind this section was to help these children, that they should not, but just because their parents have some reason or they have some quarrel between themselves, and they should, these poor children should not suffer. Now, the law has always leaned in favor of the validity of the marriage. In our country, the social fabric of the marriage is so strong that once a woman says, I'm married to this man, whether it is whichever caste it is, the law and the society respects it. Now, the section 112 is the most important section, which always leans in favor of the validity of the marriage and the children born from this marriage. It will always say that the marriage is valid. Now, here, the Evidence Act, the statute, do not differ between the different religions. You may be Mohammedan, you may be Hindu, you may be Parsi. The law says marriage is marriage, and the children born during the period of, there is a period of 280 days, which is a gestation period, which is required for procreation of the child. During this period, if any child is born in 280 days, it will be understood that the child is a legitimate child born to this man and this woman, whether they are married or unmarried. Now, let's go to the definition, which is very important, because definition you can divide in 2-3 parts. (112) Indian Evidence Act, the birth during marriage, conclusive proof of legitimacy. The fact that any person was born during the continuance of the valid marriage between his mother and any man, or within 280 days. See, valid marriage between his mother and any man. It does not say any man, or within 280 days after its dissolution. Marriage dissolve bhi ho gaya. The mother remaining unmarried shall be conclusive proof that he is the legitimate son of that man, unless it can be shown that the parties to the marriage had no access to each other at any time when he could have been begotten. Now, see, here there are 3 parts to this. One is born during the continuation of valid marriage between his mother and any man, or within 280 days after dissolution, the mother remaining unmarried shall be conclusive proof that he is the legitimate son or the daughter of the, this is gender neutral actually, but the act is more than 100 years old, so it is showing son, unless it can be shown that the parties of marriage had no access to each other. This is another third part. First part, valid marriage. Second part is 280 days. Third part is they had no access to each other at any time when he or she could have, the child could have begotten. So this is very important when say section 112 that there should be valid marriage or 280 days period the child should have born and they should have access to each other. Now this presumption, this twin presumption of the valid marriage, and also there is a one word which is used that they should not have access. Now if they have no non-access to each other, suppose the husband in another country and he has never visited in last 1 or 2 years, how can the woman say that the child belongs to the same person? There is a reason. The gestation period of 280 days is also mentioned in the section itself. Now child born in the mostly in 9 months. It is a normal period which is taken by the medical fraternity, and all of us also, that every child takes 9 months to take birth. But some babies are premature also, that is after 7 months also or 8 months also there is a delivery of the child. Now when there is a 280 days period, we have to say 9 into 30, that is 9 into 30, 270 days, and 10 days are given here and there because there is a possibility that the date may not be, the mother may not know the proper date from her menstrual period. Now section 112 is the in itself a very big box which says that completely that what are the possibilities when the child can be said that born from the one and such person. Now, after this section, we have also to look into section 114. Now, section 114 is something which says the court may presume. Now, this is another section which we do not use unless and until there is a procedure or during the proceeding we want to prove something when the opposite party said that I may not answer the question. Now, we will look into this section 114. Just a minute. The court may presume existence of certain facts. The court may presume the existence of any fact which it thinks likely to have happened, regard being had to the common course of natural events, human conduct, and public and private business in their relation to the facts of the particular case. Now, there are some illustration given. Now, see, the headline of this section is court may presume existence of certain facts. Now, we go to the explanation H. That if a man refuses to answer a question which he is not compelled to answer by law, the answer it given would be unfavorable to him. Now, this is a very important section which you can otherwise also use. That if a man refuses to answer a question, suppose a woman or man, anybody, she refuses to answer a question which he is compelled to answer by law, the answer it given would be unfavorable to him. Now, as we progress in this session, we will know what is the meaning of this when the person is not ready to answer or when the person is not ready for test. There are cases where the court orders for the medical test or the blood test and the person refuses. Now, we will have a different complete explanation about the what is the blood test and when it can be given. So before that, we will be having the discussion on the definition part. Now, say here the court may presume. So it is very important that if the court can presume, because the court who conducts the trial has the complete, I would say, the scene before it, the case before it, the proceeding before it, the documents before it, the demeanor of the clients to see. Because sometimes as a judge, the judge has the opportunity to see the client. In appeal, before the High Court and Supreme Court, the clients may not be present, but during the trial, the clients are always present. So it is actually possible that the court may have the demeanor to see the conduct of the clients, conduct of the litigants. Now, in those cases, the court may presume something, that this is the possibility, and court may order for the blood test, DNA test. This is where this section comes in the picture. Now more on this section we will discuss later on. Now there is another section, very important section, that is section 4. Section 4 of the Indian Evidence Act says that it is also about the conclusive proof of the evidence. Now here when we see the section 4, is one of a small section, may presume, whenever it is provided, just a minute, when we say section 4, may presume, when it is provided as act, court may presume a fact. Now here we have seen the fact, it may either regard such fact as unless and until it is disproved, or may call for proof of it. Shall presume. Now may presume, shall presume, these are the definition discussed here. Whenever it is directed by this act that a court presume a fact, it shall regard such fact as proved unless and until it is disproved. Now there is a second part to this definition, that is about the conclusive proof. When one fact is declared by this court act to be conclusive proof of another, the court shall, on proof of one fact, regard the other as proved, and shall not allow evidence to be given for the purpose of disproving it. Now here, when there is a conclusive proof before the court that the child is born after the period of 280 days. Suppose I gave a simple example, the person, the husband or the man from the woman who has begotten the child is out of the country for 1.5 years, and he never had access to his wife or that lady, that woman, for 1.5 years. It is but obvious that it is a more than a period of 280 days. Now there is a definitely situation where it can be presumed and it can be conclusive proof that if the court can have the documents, if the person is outside India, definitely there will be a passport entry, there may be documents if he is working outside India, there may be some witnesses which will say that he or he was not in a country. Now here in these cases, it is possible that the court may have the conclusive proof that the person was not here. Now from this conclusive proof, it has the court can presume completely that though the child is born, it is not born from the person who was not in our country. So it will be a conclusive proof of this same. So this is very important that these three sections, 112, 114 and section 4. These all you have to read in conjointly. You have to read jointly all these sections to understand what is the intention and spirit behind this section 112. Now next we go to the blood test. Now here the most important part comes to for I would say practical part to understand. Indian courts, I will not speak about the outside, what is I've read about it, that but there are a lot of changes in our country. Till date there is no statute, either CRPC or Indian Evidence Act, which somewhere says that blood test can be ordered, DNA test can be ordered, or any medical test can be taken forcibly. Now there is one exception under civil law, that is 151 CPC, Civil Procedure Code, where the court has the power to order any test or anything to a person to ascertain the truth. But beyond 151 Civil Procedure Code, I have not found out any section or any statute which says that blood test can be ordered as a matter of right. Just because somebody comes before the court and says that this child is not born from me, so I want to have a DNA test. It is not possible. So in Indian courts, they are still not very, I would say, enthusiastically or they very readily give the blood test or the DNA test. The reason behind it, section 112 protects such children unless and until their husband can prove the non-access to the wife now or the lady. Now the access and non-access are the two presumptions. If there is a presumption that the husband had access, the person had access, and this person, the person who is saying, the challenging the paternity or the legitimacy of the child, says that I am not the parent of the child, he has to bring a record or some documents or some evidence, evidentiary proof, evidence before the court that child is not born from him. If there is some, I would not say the clear cut evidence, but there should be. If he is out of country, the simple example I could have said, or the woman has actually lived apart from him for 3 years, the child is 2 years. In the case of desertion in the family matters, there also it is actually very easy to prove. But then he has to prove that he has no access to the wife. So the presumption under section 112 is very strong, and he should be able to rebut it. Rebut it was a documentary evidence. Then only the court may allow the may order for the blood test, may order for the DNA test. Now there are some judgment which said the blood test cannot be conclusive proof of the child do not belong to the parents. There are cases where the child, there is a possibility that the blood test of the both the parents are different, comes out differently, and the child is from the another group. But that will be only the initial part. For that, DNA proof has to be required. Only after the initial blood test report, the court may go for the DNA test. But in these cases also, I have read the judgments, or there are many judgments which says that the court will not brand a child as a bastard child, or will put any woman that she is not fidel, she has done infidelity in the marriage. So court will think 10 times. Once it is if they bastardize a child, it is very difficult because social stigma will be attached to the child for no fault of her or his. So court is very protective about this. Now, we remember one case of Andy Tiwari, Narendra Tiwari case. He was a big politician of all that time. And this one person, Rohit Shekhar, he went to the court, say that this person is my father. Now he wanted to have the blood test and the DNA report of Mr. Narendra Tiwari. Now the Narendra Tiwari's counsel took the help of the section 112 that it cannot force anybody, and also there is no statute that, but the court very distinctly said that 112 is for the protection of the child. Now here this Mr. Rohit Shekhar was actually major, maybe 29-30 years old, and he had every right to know who is his father. Now he wanted to prove that who was his father, he wanted to find out. So the court ordered the blood test and also for to go for DNA test. Now here, ultimately, the matter was settled amicably between the parties. But here, from the Delhi High Court, this matter, when it came in the media also, it was actually very discussed that court can order such kind of medical test. But 112 says that it is only for protection of children's offspring, small children's. Now here, the person was actually very major, maybe 20 in his 30s, and he had every right to know who is his father. And actually, it is not to, it was not going to be harmful to the child. See why 112 says that you cannot allow the blood test of the child to bastardize the child. They will not allow your application under section 112 in a matrimonial disputes. But when a child who is major, who or she is major, if she comes before the court, he comes before the court to prove the paternity, he has got every right to know who is the mother, who is the father. The applications will be out. So this is the reason this judgment is apart from all the other judgments. 112 is totally different. It proves that for paternity and for the child, for the person's sake who wants to know who are his real parents, to prove his paternity, he can always claim for blood test of the parent. Now here, now if we go to the section 114, that court may presume. Here, when Mr. Narendra Tiwari said, I will not go for a test, the court, of course, cannot force anybody to go for the blood test or go for any medical test, because that will be a violation of the person's right, fundamental rights of the under Article 21. Also, it will be intrusion of his privacy, that you are bringing his life into the public glare. Now here, but the court will presume if you refuse and form an adverse inference that if you are refusing, then under section 4, the court, it is a conclusion proof that the child belongs to him. You may refuse that I will not go for the blood test, but the court has got every right to form an opinion, also an adverse inference to be drawn, that because you are feeling that the result may, to ascertain the truth, you are avoiding this test, and the court will presume that actually, and it will be a conclusive proof that the child has actually belongs to you, the son actually belongs to you. Now in Andy Tiwari case, it is very important when we read that this is section 112 is interpreted in a different way, and it will not apply in the cases where the children are major. Now next we go to the another case, that is Asia versus Hamid. This is another important judgment which is to be read by all of us who wants to understand the section 112. Now in this matter, the husband was out of country at Saudi Arabia. He was working there. He already had 2 children. This is a judgment from the Kerala High Court. Now in this case, the Hamid was working outside, and due to some reason he has to come deported back to the our country, India. When he came back, his wife was not staying with him, and when he tried to bring her back, she was in a very frail condition. And when he took her to doctor said she is pregnant and she is about to be delivered. She is about to deliver the child. He was shocked. The child was born, and because of this, all this development, he went before the family court to prove that this child do not belong to him, because for 307 days he was out of the country from his last access to his wife Asia. So he said that the daughter born from during this period do not belong to me. But Asia took a defense that he do not want to pay maintenance to herself and the child. That's why he's taking this defense. But in this case, the Hamid has documents which said that he was out of the country for 307 days, which was not near 270 or 280 days. It was not even 290 days. Also, he had documents, and in before the family court, when this application was made by the Hamid to say that he was not the father of this child for a declaration, the family court allowed his petition, and the Asia has taken it to the High Court. The High Court could have read that all the documents which has been produced by the Hamid completely and clearly says that the child could not have begotten from him, because he had no access to his wife that time. So it was very important that he could have brought his documents. He could have also brought all the position and all the circumstances that he was out of the country when the child was begotten, maybe in her home. That time he was not there, and this is a case which went in favor of the husband. So this is totally opposite case. Now we will see one more case, that is Selvaraj case. Just a minute, I'll share the details. Now, this is a judgment from the Madras High Court of 2018, very recent one. Now, in this judgment, the husband wanted a divorce. So he had put up a case that the wife has deserted me and the child born is not from me. Now, in this case, he wanted a DNA test of the child, but the court said in favor of the wife that except desertion and the plain pleadings, the barred allegation, there was nothing in divorce petition, no documents. In Hamid and Asia's case, we had documents, but here there was no documents. And this court will never allow, on the basis of just plain pleadings, that a child is not born from me. They will not allow the DNA application of the husband or anybody for that matter. The matter went to the High Court, and High Court also held in favor of the wife that the child cannot be bastard just because you want divorce. You have to bring some documents to prove that the wife and you had never access. Actually, there was a ground of desertion taken by him, but the court say it is not suffice to bring this single ground of desertion and the bare pleading that the bald just vague allegations in that. that she was having affair or she had access to another people and she was not with me. You have to prove your case. See, 112 section very clearly says that the person who says that the child do not belong to me, child could not have begotten from me, then he has to, because he is the one who challenges legitimacy of child, he has to bring the evidence, he has to prove that he has no access to the lady. He had he should have he should produce a document which says that the child do not is not his own. So here the child, he was unable to bring anything on record, and that's why his his civil revision was dismissed, and the wife got the justice. So these are the important judgments, and 112 is actually very important section if you are having the matrimonial disputes. Also there is a cases where in criminal matters, also in some rape matters also, there is a child born. In those cases also we are able to use section 112, and it will be very helpful. So those who are doing family or matrimonial dispute, it is very important. Also in property matters, like in Andy Tiwari matter, though on the face of it, it may not, it was just to prove the paternity. But once the paternity is proved, according to lineage, the children, if they are legitimate, they will be having the property rights in the father's property. So it is very important section for the civil matters of the, for the property matters also. So always remember that section 112 is protective about the children. And if you want to disprove and if you want to rebut the presumption, it is very important that you take out some document, some evidence, a reasonable evidence to rebut the presumption under section 112. So that was all about 112. Any questions? I'm open.